Well, it's 3 o'clock, so I think we better start. I think people are still joining, but we'll kick off. And good afternoon. Welcome to Meet the Experts, which is a webinar today on assisted dying. I appreciate that assisted dying is not the most uplifting topic you've ever attended a webinar on, and I'm afraid I won't be cracking any jokes today because this is a profoundly serious topic. But before you log off in despair and run to your happy place, please bear with me, because I think assisted dying raises a number of very challenging ethical questions, which are extremely interesting. Personally, I find this a fascinating area of law, and I hope during the next 40 minutes I'm able to convey some of that interest to you. Now, there's going to be some magic here as I try and share my slides with you. Okay, the slide's up, Lily. Okay, the way I'm going to approach this talk is in 3 stages. The first is to look at the key ethical red lines or ethical questions which a jurisdiction will have to consider when deciding whether or not to adopt an assisted dying law. I'm then going to look at the existing assisted dying models that various jurisdictions have adopted, so you can see how each jurisdiction has approached these ethical questions. And then lastly, I'm going to look at what assisted dying is likely to look like in the British Isles if legislation is passed. Now, I use the term British Isles deliberately because it includes the Isle of Man, Jersey, and possibly other jurisdictions. Okay, so the first question a jurisdiction is going to have to deal with is whether to adopt assisted dying, yes or no. And this is a very divisive question, and there are extremely passionately held views on both sides of this debate. Essentially, it's a balance between protecting vulnerable people on the one hand and people's autonomy on the other. So the arguments in favour of not having assisted dying is that vulnerable people may feel pressure to end their lives. Now, this may be actual pressure from impatient or greedy family members, or it may just be a sense of feeling a burden on society once somebody's health has deteriorated. Now, to an extent, this concern will be addressed by the safeguards that jurisdictions put in place to protect vulnerable people. The concern, however, is that these safeguards will be diluted over time, and there is a fear that we'll end up, once this red line is crossed, you'll end up being in a society where people's health deteriorates, that they're encouraged to bring their life to an end. Now, the yes case is all about autonomy, and it's giving people a choice as to how they die, and giving them an alternative to going to Switzerland to use the services of Dignitas, a non-medical suicide, withdrawing medical treatment, so for example having a ventilator removed, or refusing food and water. And if you go without food and water, it takes, I guess, between 3 and 10 days to die. I did say this was not the most uplifting talk. Now, if a jurisdiction has made the decision to travel from no to yes, and it's decided it wants to adopt an assisted dying law, the first major question that it will have to consider is what the threshold to access assisted dying should be. Should it be terminal illness, or should it be intolerable suffering? Now, the jurisdictions use different language here. Sometimes it's referred to as unbearable suffering. The argument in favour of terminal illness is that it's a high threshold, and it will protect vulnerable people who don't have terminal illnesses from being encouraged to access assisted dying. Terminal illness is also objective. It's capable of an objective definition. Doctors may sometimes, but very rarely, get a terminal diagnosis wrong. But doctors are able to generally diagnose whether somebody has a terminal illness or not. The lower test of intolerable suffering is not capable of being objectively defined. It's a subjective test. Its boundaries are therefore not clear, and therefore there is some flexibility. And that's the concern between that people have of crossing this line from terminal illness to intolerable suffering as the threshold. Now, the argument in favour of intolerable suffering is really made by that title. If somebody is suffering intolerably from an irremediable medical condition, is it right to prevent them from ending their life safely if that's what they want to do? Now, if jurisdiction moves and crosses that line from terminal illness to intolerable suffering, they immediately come up to another red line. Should intolerable suffering include mental illness? And this is the issue that Canada has been grappling with over the last few years, and we're going to come to deal with Canada in a minute. So the next question that a jurisdiction will have to deal with is who should assess whether the threshold has been met? Should it be doctors? Now, this is the norm in every jurisdiction which currently permits assisted dying. Clearly, doctors are the right people to determine whether a medical threshold has been met. But are they the right people to determine whether any pressure has been exerted on somebody? And it's this concern that led the private members bill that was put before the UK Parliament in 2015 to include a provision that access to assisted dying had to be approved by a High Court judge. Now, it's obvious why that provision was inserted, and it at one level is a very good idea. But my concern about it is whether it's a practical safeguard. If the UK or England had as many cases of assisted dying as Canada currently has, you would need an army of High Court judges to approve access to assisted dying. And the other aspect of assisted dying is it's very often accessed by people in the very final stages of their life. And they don't have time to wait 3 months for a High Court judge to approve their access. Now, we're going to look at Jersey later on, but what's very interesting about Jersey is that they proposed the development or the creation of an assisted dying tribunal to answer this question. We'll look at that in a second. And the next ethical question that will have to be determined by a jurisdiction is how should medication be administered? And this is a very divisive question. Should it be self-administration, which is referred to sometimes as assisted suicide, or should it be medical administration, which is referred to as voluntary euthanasia? And I have to say I don't like these terms, assisted suicide and voluntary euthanasia, but they're frequently used, and they're actually frequently used interchangeably, but they mean different things. Assisted suicide is when the individual takes the medication themselves. A medical voluntary euthanasia is where the medication is delivered by a doctor. Now, the argument in favour of self-administration is that the individual is responsible for the end of their own life. Third-party involvement is limited to assessment and prescription. The argument in favour of medical administration is that an individual who may have met the threshold may not be physically able to administer the medication themselves, either because they can't use their hands or because they can't swallow. And you may think that it's very cruel that somebody who qualifies or has met the threshold for assisted dying nevertheless can't access it due to a physical disability. It's also a medical procedure, which is why in Belgium they only allow medical administration. Self-administration is not permitted, whereas in other countries only self-administration is permitted. So the next question is, should advance directives be permitted? Now, an advance directive is when you have capacity, you set out in what circumstances you wish your life to be brought to an end medically at some future point if you lose capacity. Now, the no camp, this is the norm in practically every jurisdiction, and most people feel very strongly that this should never be incorporated into any assisted dying law. The exception is the Netherlands, which does permit advance directives. Canada has a very limited advance directive, which is where an individual who has consented to access assisted dying and anticipates they may lose capacity at the point of their death can give consent so that if at the point of their death they're not able to consent, a doctor can administer the medication. So a very limited version of an advance directive, much more limited than what the Netherlands allows. Now, the yes camp, there is no way that the British Isles would ever allow advance directives, certainly not in the near future. So to an extent, this is a very academic question, but I suppose I put to you, and it's a question for you to decide for yourself, is would you want control over your death when you have lost capacity? Now, the last question, ethical question I wanted to consider was at what age somebody should be able to access assisted dying. Over 18, this is the norm in most jurisdictions. There are some exceptions. The Netherlands permits assisted dying for children aged between 12 and 18. Belgium has no age limit, although the age will be a relevant factor in whether or not somebody can access assisted dying. Now, Scotland in its draft bill proposes that the age would be 16 plus. And this is actually because in Scotland, that is the age of majority. I didn't realise that until recently, which is why with the Scottish referendum, 16-year-olds were allowed to vote. Okay, so those are the ethical questions. What I want to do now is look at the various jurisdictions and how they have grappled with these ethical questions. And I'm going to start with the most restrictive jurisdictions and slowly work my way through to the more permissive jurisdictions. Now, this is not a comprehensive list of all the countries that have assisted dying. I don't think we had time this afternoon to deal with every jurisdiction. So these are the primary jurisdictions, but behind which there are a number of other jurisdictions which have recently adopted assisted dying laws. Okay, I'm going to start with the United States, which is the most restrictive. There are 9 states and the District of Columbia, which is not technically a state. So there are 10 jurisdictions in America which have adopted assisted dying law. Montana is in red because it's an 11th jurisdiction. It hasn't passed any legislation in Montana, but in 2009, the Supreme Court of Montana ruled that assisted dying was lawful. Now, the model in the United States, which is uniform across all of these states, is very restrictive. The access threshold is a terminal diagnosis with 6 months or less to live and self-administration only. Taking Oregon, which is the first state to adopt assisted dying in 1997, there were 278 cases of assisted dying in 2022, and Oregon has a population of 4.2 million people. So let's move on to Australia, which has adopted, each state of Australia has adopted assisted dying laws quite recently, Victoria being the first in 2019. There are 2 territories in Australia which haven't yet adopted assisted dying, so it's not available throughout Australia, it's just in these states. Now, the access threshold, it gets a bit confusing with Australia because not every state has adopted the same rules. The access threshold is a terminal diagnosis, 6 months, but 12 months if it's a neurological condition, and Queensland is always 12 months. So there's a slight tempering of the Oregon model here. South Australia, Queensland, Victoria, and Western Australia require self-administration unless physically incapable. So again, a tempering of the Oregon model. Tasmania, self-administration unless physically incapable or concerned, and that's a psychological issue, concerned about self-administration. New South Wales allows self-administration or medical administration. So you can see Australia has modified the Oregon model slightly. In Victoria, there were 306 cases in 2022 to 23. That's actually a 12-month period. It's just they don't collect the data for on a calendar year. And the population of Victoria is 6.8 million people. So that's about the same rate as Oregon, but as you can see, Victoria's only recently adopted the law, whereas it is well established in Oregon. So one might see the cases in Australia increase with time. Now, Canada has a very different journey to other jurisdictions, to its assisted dying law. And I want to contrast it with what happened in England. In England, the case of Nicklinson, which involved a number of people bringing a claim to the in the English courts, which was heard by the Supreme Court, UK Supreme Court in 2014. And the claim was that the law on assisted dying, the prohibition of assisted dying was a breach of Article 8 of the European Convention on Human Rights. And the majority of the Supreme Court said that this was a matter for Parliament to decide. Well, the reverse happened in Canada. In 2015, in the case of Carter against Canada, the Canadian Supreme Court ruled that the prohibition of assisted dying was a breach of the Canadian Charter of Rights and Freedoms, which is their equivalent to the European Convention. And they ordered the Canadian Parliament to change the law. So in 2016, the Canadian Parliament passed a law which allowed assisted dying. And the test was that death had to be reasonably foreseeable, but there was no specific time limit inserted. And then in 2019, the Quebec Superior Court ruled that the reasonably foreseeable test violated the Canadian Charter. And so in 2021, the Canadian Parliament amended the law to remove the reasonably foreseeable death requirement. So where you end up in Canada is terminal illness is not required. So this is a major shift from the Oregon model. The test is that someone has to be suffering from someone has to be enduring unbearable physical or mental suffering, and that includes mental illness. Now, when the law was passed, the implementation of mental illness was deferred until 2023. It's subsequently been deferred further to 2024 and now 2027. And this is an issue which the Canadians are grappling with, and there is a chance that it will never be implemented, or at least not in the foreseeable future in Canada. So the test then goes on to allow self-administration or medical administration. And as I said earlier on, the final consent can be waived if natural death is reasonably foreseeable and capacity is lost just before giving final consent. So in 2022, there were just over 13,000 cases, and there's a population of 39 million. So this is a much higher caseload than you see in either Oregon or Victoria. Now, you may say, well, the reason for that is it's a more permissive law. But actually, if you look at the next bullet point, you see that 96.5 cases that went before Canada in 2022 involved a terminal illness. So it's not the breadth of the Canadian law that actually has resulted in such a high level of uptake. Switzerland, again, is completely different to other jurisdictions. There is no framework as such that we've looked at for Australia, Canada, and America in Switzerland. What they have is the Swiss Criminal Code of 1942, and Article 115 states, this is a translation, whoever from selfish motives induces another person to commit suicide or aids him in it commits an offence. Implicitly, therefore, is if you assist someone and it's not for a selfish motive, then it's lawful. And as a result of this, there are a number of charities which are not profit-making, and therefore no selfish motive. There are a number of charities in Switzerland that provide an assisted dying service. And the one that people know outside of Switzerland is Dignitas, because this is the only charity that provides a service to non-residents, non-Swiss residents. The access threshold is intolerable suffering, and only self-administration is permitted. Now, the last jurisdiction I want to look at is the Netherlands. I've looked at that a little bit so far. The access threshold is lasting and unbearable suffering, and that includes mental illness. In 2022, there were 115 cases in in the Netherlands, involving mental illness. Children can access assisted dying between the ages of 12 and 18. Advanced directives are permitted. Self-administration or medical administration is permitted. Now, in the Netherlands in 2022, there were 8,720 cases as a population of 17.7 million. So that's a higher uptake than Canada. And as you would expect, given the permissiveness of this law and for how long it's been around, it's a much higher uptake than the US or Australia. Okay, now that deals with the jurisdictions that have a law. What I want to do now is deal with the jurisdictions in the British Isles which are considering adopting an assisted dying law. So the first one is Scotland, and you'll have seen quite a lot of coverage of this recently in the press. In Scotland, there is the Assisted Dying for Terminally Ill Adults Scotland Bill 2024, which is expected to be debated this autumn. Now, the access threshold is terminal illness with no date. So slight tempering of the Oregon model. 16 plus, and that is for the reasons I explained earlier on, that 16 is the age of adulthood in Scotland. Self-administration only and no judicial approval. So it's on the more restrictive end of the spectrum. Now, Jersey is an extremely interesting model. In 2021, the Jersey State Assembly approved the implementation of assisted dying, and a law is expected in 2027. And the bill that's currently on the books contains the following. The access threshold is terminal diagnosis, 6 months or 12 months if a neurodegenerative condition. So that's like the Australian model. Or if it's an incurable physical condition. I've highlighted physical to make clear that this does not include mental illness. It's an incurable physical condition that causes unbearable suffering. Now, this is the really interesting bit about Jersey. In the case of non-terminal illness only, so that second limb, approval must be granted by an assisted dying tribunal. And the assisted dying tribunal that is envisaged will contain 3 members, a legal member, a medical member, and a lay member. So this won't be required if it's a terminal illness or there's a terminal diagnosis. You're going under that heading. Only a requirement to get consent of this tribunal if it's the second limb, which is the unbearable suffering limb. There is a Canadian-style waiver of final consent, self-administration, or medical administration. So this proposed legislation is different to anything that any other jurisdiction has, and it's considerably more permissive than the Oregon model, but does have the protections of an assisted dying tribunal, which no other jurisdiction has. Okay, Isle of Man. Isle of Man is likely to be the first jurisdiction in the British Isles to adopt an assisted dying law. It's likely to become available during the course of next year. The access threshold is terminal diagnosis 6 months, so that's the Oregon test or the Oregon model, and self-administration or medical administration permitted. Right, my last slide. I'm going to look at the England and Wales private members bill. So there's not currently a bill on the books in England and Wales, but there was a bill put before Parliament in 2015. This was a private members bill. It was overwhelmingly rejected by the House of Commons, 118 votes for, 313 votes against. That bill was the most restrictive model so far. It's effectively the Oregon model with High Court approval. So the access threshold was terminal diagnosis 6 months, self-administration only, and approval by the High Court. And this is really the bit that I've been concerned about, the High Court judge. Approval by the High Court within 14 days or as soon as reasonably practical thereafter. The problem, of course, you have is that people are sometimes accessing assisted dying on a fairly high degree of urgency in the final stages of their life. Now, Keir Starmer voted in favour of that assisted dying bill in 2015, and he's a supporter of assisted dying, and he has indicated that if he becomes Prime Minister, he has committed to allowing parliamentary time in the next Parliament and a free vote. Okay, now that's all I've got to say, which I hope gives you a fairly comprehensive, although quite rapid background to the law of assisted dying. I am now going to open up to questions, but Millie, you're going to have to help me because I've forgotten how to do this. Stop sharing. What do I do now? Okay. I was terrified. Having dealt with what is I consider to be a really interesting topic, I'd end up with absolutely no questions, but thank you, Aoife, for asking a question. What sort of model do you think England should adopt? I can tell you what sort of model England is likely to adopt, which is a very restrictive one, which, and probably along the lines of the bill that was put before Parliament in 2015. And that does concern me because I think if we adopt that bill, we will be stuck with that model of assisted dying for generations. The model that I am most attracted to is the Jersey model, which I think has taken effectively the best bits of other models and it's sufficiently permissive so as to allow people who are really struggling with very serious medical conditions to access assisted dying. But it also introduces the protection of a tribunal. And I like the constitution of that tribunal. I think having a medical member to deal with the medical issues, a legal member to deal with the legal issues, but then a member of the public to look after the interests of vulnerable people, I think is an excellent model. So I hope that if England goes down this road, that it will look very carefully at the Jersey model, and that is the model that we put before Parliament. But I was very surprised in 2015 by the adverse sort of reaction to the very restrictive bill that was put before Parliament, and people were, MPs in particular, were extremely concerned about the bill, notwithstanding that actually, if you look at surveys of public opinion across the world, you'll see that public opinion is very much in favour of assisted dying. So the law and, to an extent, legislatures are not necessarily in sync with public opinion. Thank you for that question. Are there any other questions? Sorry, they're not coming up. Oh, Melissa.
Just click that.
Okay. So next question, how do you protect doctors and other medical professionals who object to assisted dying on religious or other grounds? Yeah, this has been a big concern of the medical profession. And there are a number of doctors who, either for medical reasons or religious or ethical reasons, would not want to assist someone to end their life. I mean, I think the way this would work, and it's much like other areas of medicine like this, is that if you would develop a speciality in this area of medicine, and those doctors who are willing to assist someone to end their life would specialize in this, and those that aren't wouldn't go near it. I mean, it's a little bit like where a patient who, for example, is on a ventilator and instructs the doctor to remove the ventilator, which will result in their inevitable death. There are some doctors who are not willing to do that, and they're exempted from it. And that, I think, would be the case. I would never see a situation where doctors were required to assist someone to end their life if they were not comfortable doing so. Thank you, Anna, for that question. Now we have another question from Anne. Rupert, do you think the Dutch numbers are so high because non-residents are travelling there to avail themselves of a more liberal regime? I don't think so, although there may be an element of that. You have to be a resident, already resident in the Netherlands, and you have to be an established resident in the Netherlands to access assisted dying. So you couldn't go there. For example, if you had sort of months to live, you couldn't go to the Netherlands, become a resident and access the assisted dying regime there. I suspect it's possible that there are cases where people anticipate they may want to access assisted dying in the future, or may want to take advantage of advanced directives that they might decide to move to the Netherlands. But unlike Switzerland, the Netherlands doesn't allow what is called assisted dying tourism, which is a bit crass way of describing it. But Netherlands doesn't allow that. And Switzerland is the only country that allows non-residents to access it. So I think there may be a small number of people, but that certainly doesn't explain why the numbers are high. I think the numbers are high because I guess it's partly that's a cultural issue, but also because the regime itself is permissive, much more permissive than the Oregon model. Posts. Thank you very much for these questions. It's reassuring to know that people have been listening. Right. Lexi Straw, how do you think this will most affect clients and private client lawyers? Well, I mean, I think it's going to be part of the, I mean, if adopted in jurisdictions in the British Isles, it's going to be part of the, I don't know, we're describing part of the portfolio of advice that you could give a client about how to deal with the end of their life. I mean, currently, clients can make advanced decisions, and we should be advising our clients on powers of attorney and advanced decisions. If this law were introduced in England, this would be something that we would be advising our clients on, and we'd be allowed to. And currently, of course, we can't, because we can't give advice to clients on going to Switzerland, because that would be a criminal offence. I suspect actually that this is largely going to be an issue that individuals deal with their doctors rather than their lawyers, because it's much more of a medical issue than a legal issue. Georgina Crane, do you think that RMP's aversion to this is partially due to the English attitude to death, not to face it or talk about it? I think, I mean, it's really interesting. There were a variety of views, and I think there was definitely a cultural question or a cultural barrier in it. There was a cultural barrier in this jurisdiction to adopted assisted dying, but there were multiple reasons that were put forward. There was, as I said in the talk earlier on, there was the protection of vulnerable individuals, and that really did concern MPs. There was also the concern expressed to protecting, in particular, disabled people who felt that they would, if assisted dying law would be introduced, that they would be encouraged to end their lives. And there was a strong religious argument in favour or against assisted dying, and the religious argument being the issue of sanctity of life. So there was a multiple set of issues. But I don't consider England, maybe I'm wrong in this, I don't consider England to be a particularly religious or conservative culture. So I am surprised by the strong rejection of the assisted dying bill. I do, however, suspect that things have moved on since 2015, and there may be a greater acceptance of the law next time a bill's put before Parliament. I covered all the questions so far. Claire Sturzaker. Aside from assisted dying, do you think there is scope to improve and simplify end-of-life care, and that we as a legal industry should be campaigning for change? The current landscape is arguably very confusing, with terms such as advanced decision, living wills, etc., used interchangeably. I do, and I know that, Claire, this is an issue which you have very interesting views on. I think we need to do a lot more, because I think we need to equip people. I mean, particularly as we live, and those people on this call are likely to live much longer than in previous generations. We need to be more sophisticated about the way that we deal with death and prepare people in a legal way, i.e. with advanced decisions, for dealing with death. And as a plug, I know that Claire Sturzaker is speaking on this issue at the conference in Versailles in June. So I encourage all of the people on this webinar to rush to buy a ticket to Paris to attend that conference to hear Claire's talk. The next question. I know the Jersey model potentially involves a 12-month residence requirement. Do you think this is something other jurisdictions will consider implementing? I mean, generally they do. Countries, I know that the Isle of Man and Jersey, who are quite an advanced stage in developing their law, are very concerned with the idea of not allowing people, or not allowing what is called assisted dying tourism. And that's why the 12-month residence requirement is there. I think they're really adverse to their law being made available to people who are not typically resident in their jurisdiction. I mean, I think that's right. I mean, it is obviously helpful that at least one jurisdiction allows non-residents to access assisted dying, so that it is available to vast numbers of people who live in jurisdictions which don't permit it and probably never will. Okay, Alison Luzanne, do you feel that an advanced care decision to refuse treatment is really just a long, painful road to the same outcome? And if so, why does the law struggle with this issue so much? It's a really interesting question, really interesting. And I agree. I agree with this. I mean, the best that one can do in England at the moment is an advanced decision, and that's similar to the jurisdictions that other people live in on this call. So effectively, in my case, for example, I might write that if I lose capacity, and I might set various criteria for when I want the advanced decision to operate. The best that I can do is say that I do not want to receive any medical treatment other than pain relief, which essentially means that I would continue living until I probably the case receive develop an infection of some sort and die. And I find the distinction between setting out precisely when you would want to die and instructing doctors not to provide care for you in certain circumstances is quite a fine distinction. And it's more of a philosophical barrier than anything else. But I would say, in answer to this question, Alison, which is a very interesting question, is that people feel incredibly strongly about this issue. And realistically, I do not see any of the jurisdictions in the British Isles allowing advanced directives, certainly not in the very near future. Let's see. Thank you very much for these questions. They have been really interesting. Chelsea Turner. What are your thoughts on advanced decisions being made for individuals who suffer from dementia? How can the Dutch coffee case, when the individual is administered sedatives in their coffee, be avoided? Okay, I think what's being referred to as the Dutch coffee case is a case that happened in the Netherlands in the last few years. And the background to this case was an individual who'd been diagnosed with Alzheimer's in the early stages, set out an advanced directive and made clear the circumstances when they wanted their life to be brought to an end by medical means. Their Alzheimer's then developed and they became severely debilitated by the Alzheimer's and became very anxious and started behaving in a way that was very difficult for the care home because they became violent and very distressed. And so the family considered that she had met the threshold that she had set out in her advanced decision. However, she was asked whether she would like her life to be brought to an end, which I have to say is a strange question to ask for someone who quite clearly has completely lost capacity. But she was repeatedly asked whether she wanted to end her life, and she repeatedly said no. Having asked that question and having got a negative answer, the family and the medics involved decided nevertheless to proceed with the administration of the lethal medication. And that medication is delivered in 3 stages. The first is a sedative, and the second, which is usually given in a coffee or a drink of some food. The second is an injection which puts them into a coma. And the third is an injection that brings their life to an end. The doctor involved, I don't think it was a doctor, I think it was a medically qualified person, a person who was qualified to administer this, gave her the sedative in a cup of coffee, and she was sedated and was asleep. They then decided, for reasons which have yet to be explained, to skip the second stage and didn't give her the injection which would put her into a coma, and proceeded instead to the final injection which ended her life. Unfortunately, she came to from the sedative while that was before that was given, and started to resist the injection, physically resist the injection, and it was never. She was then held down, and the lethal dose was administered. I don't have to say I don't think this is a case against advanced directives. I think this is a case against extremely poor administration of the rules. I mean, this was an extraordinary case where all the thresholds and protections that were put in place were were ignored, and the outcome sounds, and frankly was, absolutely appalling. I don't think, but as I say, I don't think that's a case against advance directives. I just think if we were to ever introduce advance directives, it would have to be something that was extremely carefully monitored and all sorts of protections implemented. And the thing that, as I said, I find most extraordinary about this case is that they were asking her whether she wanted to proceed. And it seems like a very strange question to ask when somebody has clearly lost capacity. I think on that cheerful note, oh no, we've got another question. Miles. Do you think that people with mental illness should be able to access assisted dying? Well, you've left the most difficult question to the last. This is the most difficult question, I think. If you put aside advanced directives, which very few jurisdictions would even consider adopting, the question of mental illness is the most difficult aspect of assisted dying, and you can readily see why Canada is really struggling with this issue. I think most people are rightly very concerned about the implications of allowing people who are struggling with mental illness to access an assisted dying program. I guess also those same people will be very concerned about people who are very ill taking their life through non-medical means. So this is we're talking about an extremely difficult issue here. My view of this is, I think, in very limited circumstances, I would like to see it permitted. I think those limited circumstances are if someone is suffering from a mental illness and that suffering is intolerable and unbearable, and if there is no realistic prospect of this medical illness being treated, and I don't know whether there are such illnesses, that's a matter for a psychiatrist to decide. But if there are illnesses, mental illnesses, which could not realistically ever be improved, and someone is suffering intolerably, and they have full capacity and understand the enormity of the question that they're asking or being asked, and that they have a settled intention to end their life. And lastly, that there is a high risk that if they cannot access an assisted dying program to end their life safely, there is a high risk that they will do so through non-medical means and therefore unsafely. I think I would allow it. I would wish it to be allowed in those circumstances, because I think it would be better for them and better for their families if they were permitted to end their life in a safe environment rather than the alternative. But as I say, that's an extremely difficult question. And thank you for asking it, because it's also a very interesting question. Right. Apparently there's one more. Sorry. Oh, in the chat there's one more. Right. Okay, thank you. Apparently one more in the chat. Alice, right. Right. So do you know if there? So this is the question. I think. Do you know if there are any? If there's any case law in the Netherlands related to assisted dying? Well, there is the case that I just described, which is referred to, I think, by another participant as the coffee case. That case was investigated as a criminal prosecution. On my understanding, I think I've got this right, but I'm not 100% confident. My understanding is that the prosecution did not proceed. And so there was no conviction. I suspect because the intentions of the individual, the medical professional concerned, were not malicious. It was just grossly incompetent rather than criminally motivated. Have there been any convictions for assisted dying? If so, on what grounds? I think this is a question of Switzerland. I don't believe there have been any convictions. I think it's very carefully monitored in Switzerland. Every case in Switzerland gets investigated by the police. and it's treated as being a suicide, and the police will investigate it to make sure that there was no selfish motive involved. And I don't believe there have been any prosecutions. There was a very recent case that involved a couple who accessed assisted dying. I believe they were Swiss, so they didn't access Dignitas. I think they accessed Exit. One of them was terminally ill, and the other wasn't, but they both decided to jointly end their life. Now, in that case, the individual who wasn't terminally ill didn't actually qualify for assisted dying under Swiss law, and that case was investigated. But I believe that the court decided that there was no criminal violation by the charity involved. So that was that's the only case that I'm aware of. Right. Let's just check that any other questions. There are no questions, and I think there's no more chat. That leads me to thank everyone very much for participating. I hope you found this interesting. There is a recording of this talk which will be made available, as will the slides. Thank you very much. I wish you a happy afternoon after this talk.